While that may, your Lordship made an observation with regard to the fifth question, whether that will arise at all or not. No, it is true that since nine of your Lordships are deciding the issue afresh, there would still be, my Lord, an aspect which this bench may like to say, for the purpose of, my Lord, a discipline which the court normally follows.
That's the
What
law
was
to
the
lay down
option
in Dawoodi Bohra recently. So I don't think we need to really look at it. It would be more academic than anything else.
But that, no, it's
Maybe in some other case.
Maybe in some other case. Now it's too important for us to say that the reference is not correctly
I
made.
thought, since the question is arisen squarely here, your Lordship might as well say
Let
something.
me just take a minute or 2 minutes on how.
So the sixth point, do we formulate it or just leave it?
I think this covers.
But I,
Any other issue they want, I think this.
You can read it as apparent.
49, 50.
That is the heart of the matter, really.
What is the context of royalty? What is
Yeah.
Your Lordship will say yes or your Lordship
we
will say no.
confine it
Does
to
it really matter what India Cement said or what so and so said? Now we have
What-
9 of your Lordship.
What Mr. Dwivedi said at the beginning that there were 5 questions, we'll keep it down to 5.
Absolutely.
One more question may arise here. The scope of entry 5 of list 2, which is the public local government, which has been dealt with by the Kesoram, and saying that the act under which we are challenged comes with the entry.
But when your turn comes, you can just, we will see what.
Not speaking for ourselves, but I've discussed and what I've
So
seen.
entry 5 may have some incident.
Yes.
For us in the Constitution bench, there's a live transcript of the proceedings which are being argued here. So at the end of the day, all of you, particularly the lawyers who are in session at that point, get the transcript. Any corrections can be indicated to our IT team. But before we upload it, we have your certification on what has been.
It's very helpful, my Lord. Very helpful.
We have a complete transcript at the end of the proceeding of, in fact, by the day we have a transcript of the proceeding.
Dealing with the taxing entries, your Lordship will have enough for the day. We can go into other entries.
And we are very grateful, my Lord, for constituting this 9 judges bench. It's coming up after 20 years, my Lord. So, whereas the state is suffering from the loss of tax, the other side will be burdened with heavy taxation, my Lord. So that will be another issue, my Lord. In case the states win, then how to balance, my Lord, this? It may be running into thousands of crores, my Lord.
Yes.
So we are very grateful, my Lord, for this. The conflict, my Lord, if I may just state in a minute, my Lord, how this issue had arisen, because
One thing which we may be able to do based on the transcript in the evening. I've got a list of 7, my friend says 5. We have taken down everything he has said. In the evening, we can just go over between ourselves and give your Lordship a piece of paper saying,
Absolutely.
These are
These
the
are the
Common
agreed
questions, my lord.
agreed questions. Agreed questions.
Reducing, my lord, the number
Reducing the number as much as possible.
as much as.
in India Cement, my Lord, there was a cess on royalty imposed by the state. So the issue was never that royalty is a tax. Validity of cess which was imposed on royalty was an issue. And perhaps that case could have been disposed of, as Mr. Sirwai has said in his book, that royalty is an income, my Lord, which the state derives from as a part of the sale profits which the lessee gets from the sale of minerals. So it would have been invalid on that ground, but then the court went on, my Lord, and at one place in para 34, it said royalty is tax in the first sentence. Instead of cess on royalty is a tax. Because the issue was, what is this cess? There was no issue at all whether royalty is tax or not. The issue was only cess, and there was no argument also. But yet in the first sentence of para 34, though it noted that 4 high courts have held royalty is not tax and 1 Mysore High Court has held that royalty is tax, but it doesn't dwell on that, doesn't consider, my Lord, which is right, which is wrong, no observations. Para first sentence, it says royalty is tax. In the last sentence, it says that royalty is a return for the use of. So there was a contradiction. So when we were arguing, my Lord, before the 5 judges bench in Kesoram, And in fact, in two earlier occasions before 2 or 3 judges bench, this issue arose that there is no discussion in this and erroneous and this is contradictory and seems to be a mistake. So first bench, my lord, in Odisha Cement bypassed it, didn't answer. In the second bench, my lord, in Mahalakshmi Fabrics, they said no, there is enough material to show that royalty is tax in that judgment. So in Kesoram's case, they discussed the whole concept of royalty, which was also not discussed in India Cement. So having discussed the entire concept and all the judgments, including of high courts, that royalty, what is the nature of royalty? And then they concluded that it's a return and it's not a tax. In the process, they went into this question how to deal with para 34. They said that they summoned the original file and original judgment, which was earlier also summoned in the earlier cases. So this was a very live question bothering the court continuously. So they said that the word "cess on" is missing in the first sentence. If that word is inserted, then it becomes a consistent judgment. Or whether 5 judges should have done it, I did request it should go to a larger bench. But then that's how it is.
But the sentence is really tricky, as you have rightly pointed out in
Yes.
paragraph 34.
That's right.
The first sentence says that we are of the opinion that royalty is a tax.
That's right.
And then the last sentence of the same paragraph says,
Not a
royalty
tax
on
on land,
not a
but a
tax.
payment for the user of land.
So,
And or there are earlier paragraphs also where they consistently say it's a user on return on the user of land. And they, but then that's how this one sentence it completely derailed the whole thing. So many other judgments came which followed India Cement, and based on royalties, tax, the laws were struck down. Now, so that's how the mistake arose. And when we were arguing this matter, although in my case, Jharkhand royalty really doesn't come in, but High Court had relied upon India Cement and the other cases based on that. So therefore, my lord, this issue came up again, and Chief Justice Kapadia felt that how can 5 judges say that it's a mistake and correct it, should have gone to 7 judges, and that's how we are before Lordship. So now that we are before Lordship, it's unnecessary, my lord, to decide whether they can or not. I don't mind, however, a Lordship can observe. I think it would be clearly permissible, my lord, for a subsequent bench if it notices a clear contradiction and tries to harmonize the first and last sentence and says that if you just add cess on royalty, it becomes consistent with the whole. That's how.
Actually, in what context royalty was held to be tax in the Mysore High Court judgment will be clear if it is seen that in that judgment what was actually imposed was a license fee.
License fee.
So if there was a discussion of the facts of the Mysore High Court judgment,
Yes.
then paragraph 34 probably may have been different.
That's right. Absolutely. There the issue was whether that license fee could be taxed or not.
Yes.
In fact, no, it was.
Held license fee is a royalty in the Mysore High Court judgment.
Yes, right. So, however, since we are before a lordship of that. Now, may I just show, my lord, if your lordship has my written note, my lord, where I have extracted the sections involved, because in my case, my lord, from Jharkhand, though I will be defending Kesoram, but
Volume 1.
Volume 1, page 6. 1A. Yes, Volume 1A. I stand corrected. Actually, India's Cement Board sent all the states scurrying to find alternatives to recoup the loss of revenue. Finally, I have paragraph 4 at page 6. The old section I have mentioned, levy and assessment of cess subject to the provisions of this act and the rules framed under it, the authority shall by notification published. I'm sorry. Yes, old section 18. Subject to the provisions of this act and the rules framed under it,
Just 1 second, Mr.
All of your lordships have got minutes?
Or whether,
I'm in the same position as Justice Bhuiya, my lords. His computer.
Look at this. I mean, probably a year ago, this would have been unimaginable that everybody is on their laptops and iPads.
So
When you have a record like 40,000 pages, it would have been impossible.
impossible.
Some of us have been using laptops earlier, Europe.
Yes.
There have been more books.
Blessings.
Vodafone.
Was not there more books and lesser number of councils, now more members can be run.
Yeah. Books have all gone from the court. Not that they are not used, but they are used in the digitized form.
I don't think that there are no pretenders in the court.
I am one of pretenders. So I have two assistants, Lord, who will help me out. And some of us have an added problem of getting headaches, Lord, by looking at the computer for too long. So may I place the whole section? No, this is not under challenge, just for historical purposes.
Physically impossible.
Subject to the provisions of this Act and the rules framed under it, the authority shall, by notification published in the official gazette, levy a tonnage cess. I'm reading para 4.
Yes.
Tonnage cess assessed on the annual dispatches of coal and coke from each mine at the rates to be prescribed by the authority with the prior approval of the state government, provided that the rate of such cess shall not exceed 6 rupees per ton without the prior approval of central government. Provided further that the tonnage cess shall only be leviable until provision to the contrary is made by the parliament. Then there was a royalty cess also. An addition cess at the rate of 5% shall be levied and realized on the amount of royalty to be received by the state government. Additional cess realized under subclause 1 shall be transferred to the authority for the fulfillment of its object. Then this was amended with effect from in 1992. Levy, and this one is an issue. Levy of tax on use of land for other than agricultural and residential purposes. 1. The authority shall, subject to the provisions of this Act and rules framed thereunder, levy tax by notification published in the official gazette on land being used by any person, group of persons, company, the central government or the state government, local or corporate body for mining, commercial or industrial purposes with the prior approval of state government, provided that the tax so levied shall not exceed rupees 1.50 per square meter annually for any such land, but such tax shall not be levied on land which is subject to holding tax. So holding tax is identical tax paid on land by the agriculturalists. That's why the agriculturists have been excluded. The 2, the state government shall out of the tax so levied and collected determine the amount to be deposited into the consolidated fund of the state government from time to time. So in my case, the tax is not imposed on royalty, nor it is reckoning royalty, nor it is on the annual produce. It is directly and squarely on land and how land is bought and sold per square meter.
Qualified by the use of the land.
Use.
It's on land which is used for commercial, industrial or mining purposes.
That's right. So that is to exclude the holding tax, which is already on agriculturalists. We don't want to burden the agriculturalists, and therefore that's excluded. Now, that was one issue, which is not referred to your lordships, which will be decided by the smaller bench when it goes back, namely whether it is a use tax. That was one finding which went against, which the lordships need not decide. But as far as royalty, etc. is concerned, this tax has nothing to do with royalty, nor its measure is based on royalty. It's a plain and simple, not exceeding 1.50 per square meter.
Who's challenging?
So India Cement was there, so it was referred.
No, who's challenging this law? I'm trying to fight.
Industries and.
Some industries.
Now in para 6, I have mentioned the notification which was issued on 11th of February 1993 pursuant to the amended section 89. The dates were as follows. For industrial purpose, it was ₹1 per square meter. For commercial purpose, 1.25, and all other non-agriculture, non-residential purposes other than
What is that? Other than
1 and 2.
one small 1 and 2.
One is it. Other than 1 and 2. 150.
Yes.
In brief, my lords, at page 8, I have mentioned the findings of the High Court in my case, but I'll not reading it out. It's not necessary for the present purposes, but only thing is that they relied upon India Cement, State of Bihar, India Aluminium Company, and all those cases. Odisha Cement. Now, this having been done, my lords, your lordship may kindly have the Constitution itself.
Please.
I was just wondering, because this is being, the lordship sees my learned friends know, just a matter of housekeeping. One of the things which the High Court said was that to the use tax and.
That's what I told the court.
That is not a question referred to your lordship.
That's
what
he said.
He said that that will have to be decided by a smaller bench.
By some.
That's what I said. Lord, I'll take your lordship through first to some of the entries which have directly a relationship with the issue. The first of them, my lord, is entry 23, list 2. So to start with, under the scheme of distribution of legislative power, regulation of mines and mineral development is in the fold of the state legislature by virtue of entry 23, list 2, which reads thus: regulation of mines and mineral development subject to the provisions of list 1 with respect to regulation and development under the control of the union. So to correlate it with list 1, as the lordships are aware, the entry pertinent would be entry 54. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by Parliament by law to be expedient in public interest. So the Parliament must make a law. That's the first prerequisite. And that law must contain a declaration that it is necessary that union controls in public interest. So first law, second is declaration. And the third is, which obviously it can't be a simple declaration and you can't take it out. It must lay down, the same law must lay down the extent to which the parliament desires to control. In short, my lord, this entry is an abstracting entry. It takes out from the fold of the state completely. So to the extent, my lord, the prescription is there under entry 54, the field of the state under entry 23 gets denuded. So it's a pro tanto denudation. There's a cognate entry, which is entry 53, which does not share the same interrelationship. It does not share the same interrelationship. Entry 53 reads regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. So this is an independent entry. Before the constitution's advent of the constitution, they were smudged into one under the 1948 Act, which I'll show to your lordships. But while the constitution was approved, then they were segregated. And this was completely within the fold of the parliament. Now, yet another, my lord, is which has a similarity will be entry 24 of list 2, which deals with other industries. Entry 24 list 2, which reads industries subject to the provisions of entry 7 and 52 of list 1. Now, 7 is industries declared by Parliament. I'm reading entry 7 list 1. Industries declared by Parliament by law to be necessary for the purposes of defense or for the prosecution of war. And 52 is industries, the control of which by the Union is declared by Parliament by law to be expedient in public interest. So that has some similarity with 54.
So both 7 and 52 require a declaration by law.
Both require law, both require declaration and
public interest. And public interest.
Now 52 doesn't use the word to the extent to which. But in Ishwari Khetan's case, not and very rightly, they said that that is implicit. Entry 52 also, when you are making a law and you are abstracting, then how much you have extracted has to be specified in the law. So that was held to be implicit. Now entry 56 also carries a similarity, but not pertinent. Now we come to the taxing entries which are being relied upon by the state. The Lordship turns to entry 50, entry 49 and 50. Entry 49 is tax on lands and buildings. Now it is with respect to this entry 49, my lord, that observations have come that tax on lands and buildings should be directly on land as a unit. This expression as a unit will not occur on account of the fact that in list 1, entry 86, taxes on the capital value of the assets exclusive of agricultural land of individuals and companies, taxes on the capital of companies. So this expression, taxes on the capital value of the assets and land, is also one of the assets. So the issue, there were two competing entries in certain cases. And consequently, the court said that no, even if land is being included in entry 86, it is along with all the other assets. So therefore, it is a composite tax. Whereas tax on land and building in entry 49 is as a unit. Means as a unit, therefore, only connotes not that individually on land and building, not along with other assets which a party may be owning. In contrast to a composite tax under 86, it was a tax on the unit of land. In my respectful submission, this word as a unit doesn't indicate anything else. Then we have a lot entry 50. Taxes on mineral rights. Subject. May I place entry 50?
Yes.
Taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. So based on this, two questions would be arising. What is this mineral rights? Would it comprehend within its ambit the leased area in which the mining is to be done, or which is peripheral? Because in every leased area, there is an area which contains minerals, but in order to excavate and carry it away, win it and then dispatch it, you need some other areas, contiguous area, which is actually not containing minerals to facilitate the activity of mining. So whether it will include that mining land and the peripheral area, if I may use this expression. peripheral contiguous area. The other question is, how do we understand this expression limitations? Does this expression limitation enable Parliament to usurp the taxing power? Or is it merely imposing some kind of a cap, maybe denial, don't impose? Or can it usurp the power itself while making a law relating to mineral development under entry 54? This obviously alludes to, though not expressly mentioned, the last phrase, by law relating to mineral development, will mean a law made under entry 54, which is not a taxing provision, but a general entry. And that's how the other side raises this question, that there is a departure from Sundararamaiya's doctrine, which has been consistently followed and upheld. And recently, my Lord Justice Nagaratna has also delivered a judgment. That is in state of Karnataka versus Meghalaya. And in the 9 judges judgment in Jindal Steels. So doctrine of Sundararamaiya is well entrenched, not departed from, dissented from by any learned judge in any case.
Which really postulates that the taxing entries are separately delineated in the
There is
schedule.
no overlap. One, that the taxing entries and general entries are separate. Two, that the taxing entries as between the two lists, 1 and 2, they do not overlap. So, and the third is that the general entry does not contain a source of tax. Now, positing this, would it be permissible, therefore, to say that this limitation, which will necessarily be imposed under entry 54, because if it involves usurpation of taxing power, then entry 54 becomes a entry which is, as the other side says, sui generis, or it stands apart from the general structure and division of powers.
The question is whether a taxing power can be read into a general entry.
That's right.
Impliedly.
That's right. By extending something from the taxing entry in list 2, we make the list 1 entry a taxing entry, which is actually a general entry.
The consistent position in law is that the power to tax is identified separately in the list. And therefore, a general entry in the list will not include within it a power to tax.
Yes. So therefore, this limitation can only means putting a limit, because minerals are very important. No dispute between the parties here. They will also emphasize, I'm also conceding. Minerals are very important, right from defense down to so many other things, the infrastructure industry. Every industry needs steel and iron and so ingots and. So therefore, minerals rights are certainly very, very important. And in this respect, I will be showing to your lordships an important aspect from the Constituent Assembly debates. For the present, your lordship may just make a note of that, then that is that there was a motion moved by one of the members that entry 50 should be deleted from list 2 and kept in list 1. But Dr. Ambedkar rejected it. So if the framers had wanted that there should be a taxing power on mineral rights with the parliament, the easiest thing was to accept that and move it from here to there. Not to move that means that no, state will continue to have the power, but since it is of national importance, minerals, therefore, Parliament has a reserved power to say, to cap it. So that the states don't go berserk and they start competing and raising taxes beyond limits and extraordinary limits. So this limitation word, if grammatically understood, will not indicate usurpation, arrogation by Parliament. Contextually also, it will not indicate that. And if we keep in mind the Constituent Assembly debates, it will not mean that. So whereas, my lord, now there is a fourth doctrine that all the entries must be liberally construed. That will not mean that the limitation which is imposed has also to be so liberally construed as to completely denude the main part of it. Just as in the case of provisos, we say that proviso cannot eat up, the ear cannot rise higher than the head. So the entry has to be liberally construed, but the limitation or restriction has to be construed naturally, by natural words, whatever they mean. I am not saying that you squeeze the scope of limitation. Whatever it may naturally mean, grammatically mean, should be attributed to it. So there is a balance. In that sense, one may say it's a unique entry, though I don't see, I'll show some more entries of similar kind. So there's nothing unique. This distribution of legislative power involves balancing. Something is put there, something is here. The tilt is in favor of Parliament, both here in the distribution as well as in 246. That if ultimately, as my Lord Justice Nagaratna said, or in that judgment, that if there is a clash and conflict which cannot be resolved, cannot be harmonized, then state has to accede to the scope of Parliament's power. But when we construe the entry, my Lord, then it cannot have, the limitation or restriction cannot be expanded so as to eat up the legislative field itself. To render the entry yet another aspect is, my Lord, should not this limitation, limitation in the law made by Parliament be express, specific and concrete? Not by inferences that Parliament has MMDR Act, we read and we say that even though there is no provision which is restricting entry 50 by imposing a tax on mineral rights or a limitation on tax on mineral rights, yet we say that somewhere we find royalty, so therefore this is out. So the limitation, Parliament must apply its mind, consciously impose specific and express provisions in its law in order to limit it. It should not be difficult for Parliament to say that a tax imposed under entry 50 list 2 will not go beyond this. The submission will be that please understand limitation as something which is an express, concrete, specific provision.
But this limitation will be only in terms of quantum of tax.
Could be anything. I'm not saying squeeze it. But it should be something which is limiting. It can be in the form of principles that this formula will be applied. It could be just anything without meaning to be exhaustive about it. It could be anything which tells the state, do it in this way, don't do that. So do and don't both can come in.
Should be in the context of mineral development.
Mineral,
To encourage certain minerals to be extracted.
yes.
For the initial years of a lease, there could be a tax holiday.
Could be, minerals. They can say that for 5 years you will not impose a tax.
Yes.
They may even say, my lord, that let's say some war is going on, my lord, and for this interregnum period you will not have it. So I don't mean to be exhaustive. All I mean to say is in the negative sense that you can't expand limitations so as to say that not the state, parliament will. That's my limited purpose of.
But your first principle remains.
Yes,
You have to enact a law, and only by enacting the law, you can limit. It
limit.
can't be a matter of inference.
No. So it
Or
has to be
interpretation.
specific, express. We will not derive it from the nooks and corners of MMDR Act, my lord, that there is a limitation on this.
The limitation which Parliament can impose is a limitation in the interests of mineral development.
Yes,
It's not expressly a limitation on the taxing power only, but Parliament may well come to the conclusion that a limit on the taxing power of the states is necessary to ensure
for
mineral
mineral
development.
development. I stand corrected.
So it's not in that sense a taxing and the taxing power of the state which is restricted by a taxing power of the union. It's a taxing power of the state which is restricted by the general regulatory power of the union in that area.
And this entry itself says by
why-
law relating to mineral development. So in other words,
Government is in the interest of mineral development,
correct.
and that imposes a restriction on the taxing power of the state.
So if, correct, Manoj. Now if, I agree with that. Manoj. Now, Parliament need not expressly say that it's doing so in the interest of mineral development because it is making a law which is in the interest of mineral development. But it must have a provision which is clear, specific and express, and intention is clearly flowing that it intends to limit this taxing power of the state. And the
What is
bottom line
concept
is,
of, mineral development? What is the concept of mineral development?
so like mineral development will also involve conservation of minerals. How much mineral is to be extracted? It will also involve in what manner the minerals are to be used. Because now there is a generational, intergenerational right concept introduced by this court, internationally accepted. So
The quantum of mining which can be carried out.
yes, quantum of mining.
The bearing capacity.
That's why it requires a mining plan. Then ecological impact of it, what is happening. So that's why we require a certification from the Environment Ministry. If there are forests, that has to be. So all this balancing will be part of mineral development.
Could be a restriction on export of certain minerals.
Export of minerals, export
Even
to
if
this,
it's
not to
extracted only for domestic consumption.
yes, for domestic consumption. So that may be the width, but what I understand from my Lord Justice Oak's question was that independently of what we understand by mineral development.
Right.
So, for example, my Lord, when we extract iron ore, then there are blue fines, as we call it, my Lord, the dusty, but then all that is, and there are lumps also. So then you have to bring it to particular sizes. So beneficiation. So it's a, we'll come to that. So there are specific provisions in the MMDR Act in this respect, how to, and they are again, as I said, my lord, it's for Parliament and for the experts to decide, my lord, to what extent it can't be, we can't, my lord, define this word in a manner which makes it rigid. We have to leave it, my lord, to the times as economics develops, as the industry develops and as the needs arise. But ultimately, the law which is made limiting is the limitation itself has to be in the interest of mineral development. And as I respectfully submit, the bottom line is whatever limitations you wish, temporary, permanent, long-term, short-term, you can't usurp. You can't say, I will be imposing the tax. You may go to the extent of don't impose. In the interest of mineral development, maybe a price factor, because international prices are going up. So national prices, you have to do all sorts of balancing in economics. So you may say, stop, don't do it, don't impose, temporarily or permanently, whatever. But you can't say, I will impose.
Because taxes on mineral rights are not assigned to, they're not, it's not a subject which is given to Parliament. It is exclusively within the competence of the legislature of the state.
So in that sense, the entry seems to be, one may say that it's different from the other plain, simple entries like tax on land and buildings. But the power is exclusively within. Now read this with 246(3). Any idea of usurpation goes against the grain of 246. Subject to clauses 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to the matters enumerated in list 2. So any idea of usurpation goes against the grain of this exclusivity.
At the same time, you have to see what in pith and substance is the imposition.
Yeah, that can always be seen. Because labels will not decide the substance. Pith and substance doctrine will have its play. But at the moment, I'm only trying to question this possible submission which is being made and earlier made in cases that because of MMDR Act and because there is Section 9 royalty, therefore, my lord, this is denuded. Or the other submission that once a complete code is there under entry 54, therefore 50 is ousted. That cannot happen. And entry 50 cannot go into entry 54. Parliament cannot itself impose the tax under entry 54. For that's one, that's not a taxing entry. Second, Constituent Assembly rejected the shifting of entry 50 to list 1.
Just one thing. Entry 54 of list 1 is not a taxing entry.
Non-taxing entry. And secondly, the Constituent Assembly rejected the shifting of entry 50 to list 1. And thirdly, entry 50 is the exclusive power of state. And fourthly, limitation word by its very nature, considered naturally and grammatically, cannot result in abstraction of taxes on mineral rights into the fold of Parliament.
Interestingly, in 54,
Yes,
as the Chief Justice just now was commenting, regulation of mines and mineral development is there in 54,
yes,
and in 50 also,
yes.
Parliament by law relating to mineral development. So
that-
this expression is used twice
That's right.
in both list
So
1 and
this,
list 2.
this indicates that that limitation must
Limitation
come
is-
under entry 54. It is the same kind of law which is contemplated. Whatever law Parliament will make, it will make either with respect to list 1 or list 3. So this word of limitation is not is independent empowerment of Parliament to make a law, but is an allusion to the law which the Parliament can make by virtue of the entries in list 1 or list 3. Otherwise, we will,
Parliament can really, in that sense, impose a restriction on the taxing power of the state. But the taxing power still continues to vest with the state,
that's the humble submission.
always.
Taxing power cannot be drawn.
Three of list 2
Yes,
is also subject to entry 54 of list 1 because they are the same with regard to mines and mineral development, but
I oblige.
it is subject to
Subject matter is identical.
identical but subject to list 1,
That's right.
entry 54.
That's right. So law will be under list 1. The only difference, Lord, with if we compare 23 with 50 is that 23 does not use the expression subject to any limitations imposed there. The entire entry is subjected.
It is subject to the provisions.
Yes. Whereas here it says subject to any limitations imposed. That's a contrast between the two.
Yes.
I'm grateful for this. Now, this entry, Lord, in no way, entry 50 list 2 is not in any sense unique. Kindly have 57. Taxes on vehicles, whether mechanically propelled or not, suitable for use on roads, including tram cars, subject to the provisions of entry 35 list 3. So here again we find a taxing entry in the state list which alludes to or which is subjected to list 3,
There's no entry in the state.
which apart from fee doesn't contain a taxing power. Kindly see entry 35 list 3. Mechanically propelled vehicles, including the principles on which taxes on such vehicles are to be levied. So although both state legislature and parliament can make law with respect to list 3, but parliament has an overriding power. But while making a law, parliament with respect to entry 35 can only lay down principles.
Principles, yes. Entry 63 of list 2.
63 of list 2.
Rates of stamp duty.
Stamp duty in respect of documents other than those specified in provisions of list 1 with regard to rates of stamp duty. Entry 91,
Entry 91 of list 1.
Of list 1. Rates of stamp duty in respect of bills of exchange, checks, and so on. But in case of this 91 and 63, once these documents are actually out of the fold, only parliament can impose tax. Whereas so far as 50 and 57 are concerned, the power of parliament is limited. In one case, limitation word is there, in other case, general principles. Yet,
but interestingly, on stamp duty,
yes,
the main provision is in the concurrent list.
yes.
Entry 44 of list 3. Stamp duties, other than duties or fees collected by means of judicial stamp, but not including rates of stamp duty. And why is rates taken out of entry 44? Because the rates in respect of some documents are introduced in the union list.
Yes.
Rates in respect of all other documents are introduced in the state list.
That's right.
But the power is a concurrent power.
Yes. So that if the states have imposed some rates, parliament can override that.
In respect of
Rates.
right. No, but parliament can't override the rates at all. The power to impose rates is exclusively assigned to the state, except in respect of the excluded entries.
Not including the rates of state.
But the power to levy a stamp duty is given both to parliament and the states.
Yes. Now, kindly also, there's another interesting entry in list 1, which is 32. So it's a general entry. Property of the union and the revenue therefrom. What should have this entry 32?
Yes.
And the revenue therefrom, but as regards property situated in a state subject to legislation by the state, save in so far as parliament may by law otherwise provides.
An exception to an exception.
Yes. So ordinarily it's the states, but if the parliament does not want the states to do that, then it provide otherwise. Now, all this provision otherwise, and the reason for alluding to this is that parliament by law otherwise provides, again, these have to be specific, concrete, express. They can't be by inferences, by mere implications. At best, there should be a strong implication.
One other interesting aspect which would support your submission is entry 97 of the residuary entry.
Yes.
Of list 1, which says any other matter not enumerated in list 2 or list 3, including any tax not mentioned in any of the lists. So if a tax is mentioned in any other list, then parliament can't exercise the residuary power of legislation to enact that tax.
Even under 97, it cannot. And this has to be read with Article 248. 248 is pertaining to the residuary powers. 248 reads this, subject to Article 246A, Parliament has exclusive power to make laws with respect to any matter not enumerated in the concurrent or state list. So 246(3) exclusivity, 248(3), they're all consistent, 97.
Section 2 of say, Article 248 is more pertinent.
Such power shall include the power of making any law imposing a tax not mentioned in either of those lists. So not only the field of legislation, but which has to be read with the power under 248, read along with that, is indicative of the fact that there is no arrogation of taxing power reserved for the state contemplated. So the scheme of Sundararamaiya, as endorsed by subsequent judgments, stands reinforced rather than diluted by entry 50. And all these expressions of subject to, etc., not including this, excluding that, these are meant to balance and distribute the powers in the larger national interest and state interest. And to complete this chain of thought with regard to entries, there's a doctrine developed by this court, and that is with respect to federalism being a basic feature of the Constitution. And that is a doctrine which applies in a limited way, because ultimately federalism has two parts, both the center and the state. But what this doctrine evolved by this court says is that don't expand the phraseology so as to deprive the state of its taxing power or any other field of legislation. If the subjection to the parliamentary domain, parliamentary legislative power, is clearly and specifically flowing, it has to be honored. So that is the scheme of the Constitution. But if there is doubts or ambiguity, etc., then the effort should be to preserve the state's power rather than rule in favor of its denudation, which I will show the judgments. So that completes the entry and
Also,
the...
Mr. Dwivedi, the doctrine of occupied field does not really apply in a conflict or where the subjects are in list 1 and list 2. The doctrine of occupied field, where the mere enactment of a law or the failure of Parliament to enact a law has no bearing on whether the states should or should not legislate. If it's an occupied field, then by virtue of the fact that it is occupied by a law made by Parliament, the states are completely denuded. But that's only in respect of list 3.
Yes.
So, yes, this expression occupied field, your lordships have deployed in two senses. One is list 3, where your lordship says that if the Parliament has exhaustively covered the entire field with regard to a subject matter, then states cannot trench upon that field And if the states have already made a law in that, then it will survive only to the extent it is not repugnant, and Article 254 becomes the key to resolve it. And the other is, this expression has been used is in the context of entry 23 and 54 and 24 and 52, where your lordships have said that if Parliament has made a law with regard to mines and mineral development, and that covers the whole field, then the states cannot. So much so that if regarding minor minerals, Parliament doesn't itself, but it contains section 15, which says the states will make rule on these subjects regarding minor minerals. So the states must act as a delegate under section 15. It cannot make its own law. So it's in that sense, that this expression has also occurred and repeatedly deployed. All that your lordships have warned is that we must clearly demarcate whether the field is covered or not. So whenever somebody says that this field is completely covered by MMDR Act or any other oil offshore mining act, then one has to read that act and see that what the state has done, is it occupied there? If it's not occupied, then state's law is good.
That is why it says to the extent to which.
To the extent to which, I agree. I will come to that. I'm sorry, but one more provision I need to show. 86, Article 286. I'm more concerned with 286.3, but I'll read the whole of it so that the context is clear. 286.1, no law of a state shall impose or authorize the imposition of a tax on the supply of goods or of services or both, where such supply takes place A, outside the state, or B, in the course of import of the goods or services or both into, or export of the goods or services or both out of the territory of India. Then 2, Parliament by law formulate principles for determining when a supply of goods or services or both in any of the ways mentioned in clause 1. Now 3 has been deleted subsequently in 2016. But if your lordships will look at the footnote 4, I hope your lordship
Yes,
is
there.
Clause 3 omitted by the Constitution 101st Amendment 2016 with effect from 16 September 2016 was substituted by so-and-so. 3. Any law of a state shall, in so far as it imposes or authorizes the imposition of a tax on the sale or purchase of goods declared by Parliament by law to be of special importance in interstate trade or commerce, or B, a tax on the sale or purchase of goods being tax of the nature referred to in subclause B, C, D of clause 29A of Article 366. Be subject to such restrictions and conditions in regard to the system of levy, rates, and other incidents of the tax as Parliament may by law specify. So entry 54, if it is a good, particular good is declared to be of special importance, then it will be subject to restrictions and conditions, which issue did arise in this court, and lordship said the restrictions and conditions must be specific, express, and concrete. Otherwise,
I mean, it has no bearing on what your argument. Look at clause 2 of 286. It doesn't make sense now.
yes,
Just see, it says Parliament may by law
formulate principles for determining when a supply of goods or services or both in any of the ways mentioned in clause 1.
So
it's, you know what happened was, now see footnote 33.
Yes.
The original word was sale or purchase of goods takes place. While making the amendment after the GST legislation was enacted,
Yes.
they deleted the words takes place. The words takes place should have been retained in clause 2.
Yes.
Otherwise, clause 2 has no meaning now.
That's right.
As Mr. Sarvis, it's a fossil. But,
Yes.
but they, by mistake, the draftsperson took away the words takes place also from
Yes.
286.2.
But maybe by formulating principles, it can be brought back, my lord.
Formulate principles for determining when.
And
They
where.
said now supply, because in the GST legislation, it's not sale or purchase, it's supply.
Yes.
But you had to put the word takes place. Takes place is just taken away. Anyway, you referred to 286.3, right?
Yes. I refer to it because I'll be relying upon a case which is directly on this note to say that there should be specific and later.
What next, Mr.
Now, my lords, I would like to place the Mines and Minerals Development Act, my lords, because that's a law made by Parliament, which is immediately in issue.
Is it already in a digitized form? Sorry.
I don't think there's anything he has said which is controversial from what I've heard. In some jurisdictions, Malad, they say in a case like, please lead counsel, sit down together and formulate a list of propositions or laws to which you are all agreed. So then one of them reads it and that's it. And then focus your submissions on what you don't agree on.
So I think we can do that, we've also taken down what Mr. Dwivedi has said.
No, like my friend is arguing. We could all say we agree to all this. You don't need to go over a lot of.
So perhaps on your side, you could tell us tomorrow, at least we can implement it in part, so that you would have, now anyway, we have taken an hour plus, on what are those propositions about which there is no real dispute over here on this side completely.
Or maybe after I finish, my lord, they may not dispute anything.
Which makes it quite possible because we are actually running on parallel tracks.
I have Kesoram to defend.
Yes. Is the MMDR Act in the digitized form also, or?
Volume 4, page 910.
It has all the statutes as well.
48 किसमें? Kindly first have page 891, my lord. There was a predecessor act which will have some relevance.
You're showing 48, right?
48.
891 in the
Yes.
volume PDF.
Now, this was a law made by the Constituent Assembly itself, acting as the Parliament
Parliament
under
at that
the
time.
India Independence Act 1947. And it was exercising all the powers which was earlier being exercised by the Governor General in Council. Because the Government of India Act 1935, to the extent of federation, never came into existence.
Right.
So the Government of India Act 1919 continued, and the powers of the Governor General in Council were the same there. So all those powers vested and read with India adaptations under the India Independence Act. This law was made, received the assent of the governor. It's a short law, received the assent of the Governor General on the 8th September 48 and is published in the Gazette of India Extraordinary dated 8th September 1948. An act to provide for the regulation of mines and oil fields and for the development of minerals Whereas it is expedient in the public interest to provide for the regulation of mines and oil fields and for the development of minerals to the extent hereinafter specified, it is hereby enacted. And this act may be called the Mines and Minerals also. It extends to all the provinces of India and also to any exceeding states for which the central legislature has, for the time being, the power to make a law development of minerals. Now, Lordship, will see that both oil fields and that, they are covered by this same. They were not separately dealt with. Section 2 contains a declaration, but it could not be a declaration under 54 because Constitution was not there, and that was one of the problems in. Oh, I'm so sorry. The date, yeah.
8 September. 8 September 1940.
The Lordship will notice, the historically significant something that it says that provinces of India and to exceeding states. By this time, the issue of accession had not been finally settled. It's September. And this Hyderabad and Junagadh and Kashmir issues were still alive.
That's very interesting, actually.
Yes. So they say exceeding states. And they also say has for the time being the power. Because some states which had exceeded, they had exceeded only on 3 subjects, and some had already stated that they accept the constitution which is coming. So these variations are taken care of.
1950, January 26.
Yes. In fact, Goa came much later. Goa was probably
Goa, Dadra and Nagar Haveli.
Dadra and Nagar Haveli and all that. 60s, yeah. Yes. The third 3 is the definition. And you'll also see C, minerals includes natural gas and petroleum. But now under the MMDR, they have excluded it and separate. Oil field is in E. Then 4, 5, we can leave, kindly have 6. Both 5 and 6. The central government may by notification in the official gazette make rules, I'm reading section 5, for regulating the grant of mining leases or for prohibiting the grant of such leases in respect of any mineral or in any area. But that was those times, the idea was that investments were not there in the private sector, so state had to do it, so they could prohibit also. Even today, the state and central government can reserve. In particular, without prejudice to generality of foregoing power, such rules may provide for all or any of the following matters. A, manner in which the mineral or areas in respect of which, by whom applications for mining leases may be made. B, authority by which the terms on which and the conditions subject to which mining leases may be granted. C, the maximum or minimum area and the period for which any mining lease may be granted, and terms on which lease may be granted with respect to contiguous area may be amalgamated. Fixing of the maximum minimum rent payable by a lessee, whether the mine is worked or not. Then 6, central government may by notification in the official gazette make rules for the conservation and now kindly have I, section 6I. The levy and fellowship has section 6I.
6I.
Review of
The levy and collection of royalties, fees, or taxes in respect of minerals mined, quarried, excavated, or collected. Now, this is significant because both powers were with the central government. By exercising a rule-making power, it could fix both royalties, fees, and taxes in respect of minerals. Section 7 pertains to modification of the existing leases. under section 10, it had to be laid, the rules had to be laid before the legislature, central legislature. It's a matter of some interest, section 13, that even the crown was bound, because at that time we were dominion,
Right.
not yet declared to be a republic. So the crown was also.
This had a typo.
Sorry?
Whether
There's an error.
Whether-
Last part, last part.
Whether
Yes,
The
it's
crown
like
is
that.
typo.
You have to count about
this is the typo.
That's it. There are two typos in fact, after or also.
or also.
Yeah. Why? Listen.
47 actually, these are the rules after this.
Of section 6, I is that royalty and tax are both mentioned and as powers to be exercised by central government.
Yeah.
This significance will arise when when your lordship sees section 25 of the present act, which talks of recovery of taxes. So, because one of the questions was that section 25 is talking of recovery of taxes, but there is no provision imposing tax. So unless you treat royalty as a tax, the connection snaps. So the reason for mentioning will be evident once I place. This explains why section 25 has the word tax. Now kindly have the main act which is still operating. That is MMDR Act 1957. Volume 4, page 910. If your lordship has the bare act, not that will be containing other rules also. Kindly see, I'll only point out the relevant provisions. Section 3AC is the leased area. The declaration is contained in section 2. Now this declaration will be under entry 54. AC is the leased area, means the area specified in the mining lease within which the mining operations can be undertaken and includes the non-mineralized area required and approved for the activities falling under the definition of mine as referred to in clause I. Now, AE is mineral concession, which is very widely worded, includes mining lease, the CONESA permits, prospecting license, composite license, and all this. Small c is mining lease, means a lease granted for the purpose of undertaking mining operations, includes sublease. D is mining operations, means any operation undertaken for purpose of winning any mineral. And FA is production, or any derivative word of the word production, means the winning of or raising of mineral within the leased area for the purpose of processing or dispatch. You can leave out for definitions of prospecting, etc. By virtue of section 4, all mining has to be done under the licenses, permits, and lease. Section 6 is maximum area. 7 is periods, 7 and 8. Now 8 is the new provision which now requires that initial leases will be of 50 years, the rest all by auction. Kindly come straight to section 9. The holder of mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or in any law in force at such commencement, pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sub-lessee from the leased area after such commencement at the rate for the time being specified in the second schedule in respect of that mineral. Two, the holder of a mining lease granted on or after the commencement of this act shall pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area at the rate for the time being specified in the second schedule in respect of that mineral. So both old leases and the new leases will be subjected to charge of royalty. The only exception with regard to coal is 2A, that to the extent the workmen consume coal for their own purposes, subject to limitation, royalty will not be charged. And 3, subsection 3 says, the central government may by notification in the Gazette amend the second schedule so as to enhance or reduce the rate at which royalty shall be payable in respect of any mineral with effect from such date as may be specified in the notification, provided that the central government shall not enhance the rate of royalty in respect of any mineral more than once during any period of 3 years. So that then is the provision of royalty and 9A.
Royalty is not defined under that.
No,
It's not defined.
no. All that it says is that royalty is in respect of minerals which are removed or consumed from the leased area. And if your lordship looks at the second schedule, your lordship will find various, just a glance, we are not referring to any particular mineral here. But the second schedule has a detailed list of different minerals, different rates, ad valorem, so question, my lord, one of the question is whether this royalty which is levied under section 9 is in the nature of tax, either on a plain reading or by, my lord, bringing in article 366(28) of the Constitution, which says, which can be seen at this stage. Tax,
That's the main question.
that's,
Everything revolves around nature of the royalty.
that's right. Tax or impost is the word used there. So how do we understand this word impost? Kindly have a look at section 366.
Section 36.
Article 366, 28. Taxation includes the imposition of any tax or impost, whether general or local or special, and tax shall be construed accordingly. So one question is, how do we look at this word imposed as something completely different from the word along with which it occurs, namely that it should be in the nature of a tax. And the other would be, my lord, that irrespective of the label or the nomenclature which is used, because this issue has risen several times. Whether it's cess, which is it a fee or is it tax? Is the fee in the nature of tax or tax in the nature of fee? So
What is the implication of holding it one way or the other?
if the Lordship holds that royalty in Section 9 is a tax, then the next step which the respondents take is that royalty is with respect to minerals removed or dispatched, so it has connection with the minerals, the mineral rights, and consequently, it will be a provision which is a limitation within entry 50. That will be one inference with regard to royalty. So it will be, therefore the question arises, if we treat this as a tax, then it becomes a case on a plain reading of 9, 1, 2 and 3, where Parliament has arrogated to itself the power to impose tax. It's not imposing any limitation. You will not do it, I will do it. That's the consequence of considering it a tax. He says only central government by notification can amend the schedule so as to enhance or reduce. So the Parliament then will not be limiting the state's power, but will be assuming the power to itself to fix, to enhance, to reduce. That's how the word limitations, the ambit of the word limitation itself becomes an issue.
Yes.
And this is quite apart from the fact that the expression royalty has been used even in the 48 Act. When the Parliament was mentioning both royalty and tax side by side.
Right.
But now your Lordship will not find any provision which imposes a tax. It does not use, except in the case of recovery, that is Section 25. It was necessary to have the word tax in Section 25 in a recovery provision alone because 1948 Act had empowered the Parliament to, central government to impose tax also. And it was possible that there are taxes due when this new Act comes into force.
Right.
So the recoveries would still have to be made up with respect to those tax dues. And consequently, only tax is there. We'll come.
Which is the next provision you want us to see?
So only one thing, section 20, for 25 says, tax fee or other sums due to the government under this act. You can't go to the old act. Then.
Subsection 2.
No, subsection 1 of section 25 says, tax fee or other sums due to the government under this act,
Yes.
not under the old act. This will not empower recovery of outstanding tax under the old act.
So I'll just show to your Lordships, straight away kindly see section 29.
Yes, existing.
Section 29 continues the existing rules, Lord, so as if they are made under. As if this act has been in force on that date. All rules made or purporting to have been made under the Mines and Mineral Regulation and Development Act 1948 shall, insofar as they relate to matters for which provision is made in this act and are not inconsistent therewith, be deemed to have been made under this act as if this act had been in force on the date on which such rules were made and shall continue in force unless and until they are superseded by any rules made under this act. So those the rules under the 48 Act were made in 1949. So they were continued. This act itself came in 1957 after the first elections.
Yes.
And the rules, as a lordship are aware, were made in 1960. Mineral Concession Rules 1960, which repealed the old rules. That appears to be the only intent of 25. Otherwise, it's a recovery provision, as the lordship will see on a plain reading. It says, any rent, royalty, tax, fee, other sum due to the government under this act or the rules made thereunder or under the terms and conditions of mineral concession may on a certificate of such officer may be specified, be recovered in the same manner as an arrear. It's not a provision. 25 doesn't impose a tax.
The recovery provision.
Recovery. And it's an omnibus provision, so whether it doesn't take care of what is due or not due, it lumps together everything and gives a wide power for recovery. But the tax imposition has to come by some specific provision. And royalty is something, Lord, there's one concept, Lord, which in Gannon Dunkerley, which your lordship deployed, namely, Lord, that if a particular expression like sale was being commonly used and understood in a particular manner in the sense of Sale of Goods Act. So therefore, wherever this entry 54 of the word sale was understood in that sense. Likewise, royalty, Lord, was not something unknown. This was being recovered. In fact, one finds mention of this in even Kautilya's Arthashastra. So Iron Age, Lord, came much before, so mining is not that was unknown to India, only after the Britishers came. So with respect to, one clearly understands, state is the owner of the minerals. There's no dispute again, I hope so. Unless and until, my lord, the land, etc. is acquired specifically by Parliament under some law.
No, there may be a dispute where the land is a patta land. That again is a controversy.
Then there is a private person who will be owning. And that is a very important aspect which I am relying upon. If royalty is a tax, and if state is mining on a private person's land, then it has to pay royalty to that private person. So is the state or the central government not paying royalty tax to the private person? So royalty, therefore, is consistently used in the sense, prevailing sense, namely that it is a return for parting with my ownership right to the lessee. The state and the government can itself mine, extract minerals and sell it. Instead of doing itself, it grants a lease. And under the lease, the lessee then assumes that right. And a lease is nothing but a contract.
What happens if the owner of the land himself mines?
Then no royalty, it won't
No
be.
royalty is due.
Yes. But if it transfers that right, then it says, all right, you will be selling, you will be earning profits. So I must get it. It's just like, Lord, if I author a book and I give it to a publisher, I transfer my copyright to the publisher and the publisher earns profit on that by publishing a number of copies. So I say that I must get as an owner. So it's no different. And that's how it is used. Now see also 9A, which is dead rent.
Crown was the owner of it.
9A, dead rent. It is intricately connected with royalty because if somebody doesn't mine, even then he has to pay dead rent. The holder of a mining lease, whether granted before or after the commencement of the Mines and Minerals Regulation and Development Amendment Act 1972, shall, notwithstanding anything contained in the instrument of lease or in any other law for the time being in force, pay to the state government every year dead rent at such rate as may be specified for the time being in the third schedule for all the areas included in the instrument of lease.
Yes.
Then proviso is important. Provided that where the holder of such mining lease becomes liable under Section 9 to pay royalty for any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the leased area, he shall be liable to pay either such royalty or the dead rent in respect of that area, whichever is greater. So if the mineral dispatched result in a royalty which is lesser than the dead rent, then you have to pay dead rent. If you don't mine at all, you still have to pay dead rent. So that's the price which I am asking for myself, for them, namely the state, because the land has mineral and has been given to you for purposes of certain activity. So dead rent assures a minimum return and royalty may be a higher return or a lesser return. But only one of the two is payable, whichever is greater. Just to note, kindly just note section 13, which is the rule making power of the central government. 13(2)(I). Empowers rules for making of rules for regulating the grant of mineral concession. And then 2(I), some specific illustrations. One is, I is the fixing and collection of fee for mineral concession, surface rent, security deposit, fines or other fees or charges, and the time within which and the manner in which the dead rent or royalty shall be payable. So the manner, the rate is etc. fixed under 9, dead rent under 9A, and the manner of payment. Section 15(1)(a) small g is for minor minerals, and the state has power to make rules. Then kindly have section 17. As the caption of above section 17 shows, it's a special powers of central government to undertake prospecting or mining operations in certain cases. Subsection 1 of section 17 says provisions of this section shall apply in respect of land in which the minerals vest in the government of a state or any other person. Then kindly have 3. Where in exercise of the powers conferred by subsection 2, the central government, I'm sorry. Where in exercise of the powers conferred by subsection 2, the central government undertakes reconnaissance, prospecting or mining operations in any area, the central government shall be liable to pay reconnaissance permit fee or prospecting fee, royalty, surface rent or dead rent as the case may be, at the same rate at which it would have been payable under this act if such reconnaissance, prospecting or mining operations had been undertaken by private persons under a mineral concession. Now, if we treat royalty as a tax, then it will be a strange case of the government paying tax to the private persons. Therefore, royalty under this act cannot be understood as tax. It has to be understood as a return. Because the land belongs to and mineral belong to the private person. To the private person, you have to recompense him by paying a return which you are yourself charging. The only difference will be that royalty is not being fixed by the private person, but under section 9. That's a matter of regulation. Now 17 capital A, reservation of area for purposes of conservation. The central government, with a view to conserving any mineral and after consultation with the state government, may reserve any area not already held under any prospecting license or mining lease, and where it proposes to do so, it shall by notification in the official gazette specify the boundaries of such area and the mineral or minerals in respect of which such area will be reserved. 1A, the central government may, in consultation with the state government, reserve any area not already held under prospecting license or mining lease for undertaking prospecting or mining operations through a government company or corporation owned or controlled by it, and where it proposes to do so, it shall by notification in the official gazette specify the boundaries of such area and the mineral or minerals in respect of which such area will be reserved. Now with this, if your lordship sees 2A, where in exercise of the powers conferred by subsection 1A or subsection 2, the central government or the state government, as the case may be, reserves any area for undertaking prospecting or mining operations or prospecting operations followed by mining operations, the state government shall grant prospecting license, mining lease or composite license, as the case may be, in respect of such area to such government company or corporation within the period specified in the section. Now, having got this, kindly turn to advert to subsection 3.
That's important. That's important.
Although 2C also envisages some payment not on account of this, but pertinent is 3, subsection 3, where in exercise of the powers conferred by subsection 1A or subsection 2, the central government or the state government, as the case may be, undertakes prospecting or mining operations in any area in which the minerals vest in a private person, it shall be liable to pay prospecting fee, royalty, surface rent or dead rent, as the case may be, from time to time at same rate at which it would have been payable under this act if such prospecting or mining operations had been undertaken by a private person under a prospecting license. So where the minerals are vesting in the private person, it makes sense that if it is a return for the parting of the ownership right to extract minerals and sell them, then it's a consideration virtually. As in the case of Excise Act, they say that it was a privileges part, or in the case of Spectrum, which is owned in trust by the central government. So they can charge, call it license fee, royalty, etc. They are all considered to be consideration. A share, I would put it as a share in the mineral value. My Lord Justice Oak was asking about mineral development. There's something in section 18.
Right, correct.
The whole chapter begins with this development of minerals. Opening of new mines, excavation, collection of minerals taken by owners of mines for purpose of beneficiation, new borings, shaft sinkings. So it's understood in a slightly wider sense. And we have section 21, of course, is penalty, but if somebody unlawfully mines, under subsection 5, he will still be subjected to payment of rent, royalty, or tax, as the case may be. Now, this again, my lord, is one, a recovery provision. And here, my lord, after the word tax, your lordship will find as the case may be.
Where, Mr. Advedi? 21?
21(5).
Right.
Whenever any person raises without any lawful authority any mineral from any land, the state government may recover from such person the mineral so raised, or where such mineral has already been disposed of, the price thereof, and may also recover from such person rent, royalty, or tax, as the case may be. Then is section 25, which is one of the provisions relied upon by the respondents. Some of them are appellants, but I'm using this expression generically on the other side. Any rent, royalty, tax, fee, or other sum due to the government under this act or the rules made thereunder or under terms and conditions of mineral concessions may, on a certificate of such officer as may be specified by the government in this behalf, by general or special order, be recovered. So just like that other provision, this is also, now in 1972, this subsection 2 was substituted. Any rent, royalty, tax, fee, or other sum due to the government either under this act or any rule made thereunder or under the terms and conditions of any mineral concession may, on a certificate of such officer. So again, a recovery provision after 72, but it continues to use the word tax. The nature is recovery. (29) I have already read. And 33 may be seen, which is also the last section of this act. All acts of executive authority done, proceedings taken, sentences passed under the Mines and Minerals Act 1948 with respect to regulation of mines and development of minerals during the period 26 January 50 and ending the date of the commencement of this act, by government or by officer of the government or by authority in belief or purported belief that the acts, proceedings, or sentences were being taken or passed under the said act shall be valid and operative as if they had been done, taken, or passed in accordance with law. So even if there was some irregularity or something, there's still. Now, apart from this, there is no other provision which levies specifically any tax. Your lordships have seen that royalty is payable even by the government to the private person, which is something which India Cement did not note at all. Now, just one rule, mineral concession rules, as a lordship will find. Page 897, volume 4.
The 1960. 1586.
1586.
In the same volume, I think.
I'm sorry, page 1586. Volume 4. Kindly have Rule 64, capital A, which is only.
Follow my.
Page किसने? Rule 64 है. Sharing वाला कौन सा था? 57. Authority below is the central government. Kindly see chapter 4 of the Mineral Concession Rules 1960. At page 1595. Please see the caption, grant of mining leases in respect of land in which the minerals vest in the government. Then please advert to Rule 27. C, 1C, 27 1C. The proviso. The proviso says, provided that the lessee shall be liable to pay the dead rent or royalty in respect of each mineral, whichever be higher in amount, but not both.
27, is it?
Yeah.
27. Proviso. 1601.
Yes, 1601.
1601.
1601.
16 starts.
Stay for D is important.
Very important.
May I continue after lunch?
Continue after that.